Good evening, students. Good evening, Chanu. Good evening, Kritika, Veerpal, Sai Charan. Good evening, all of you. HJ, hi. Harsh Jain, right? Harsh Jain from Kota. Simi, good evening. So, how was 2 days like? Good evening, Gargi. How were last 2 days like? What did you do between 4:30 to 5:30 in the evening? Good evening, Karishma. Today we'll start with Article 143 of the Indian Constitution. Do you know what is Article 143? Anyone? Okay, you were attending CSAT class. CSAT also Ankit sir takes it, na? Ankit Tiwari sir. Article 143 relates with presidential reference. President has the power under Article 143 to seek the legal opinion of Supreme Court on any matter of importance. But before understanding Article 143, I have no idea how much you have studied about this particular topic in your polity. So I'll give you a background. Then I will talk about Article 143. And then afterwards, I will tell you what was the legal opinion of Supreme Court this time on the references that was given to it by the President of India under Article 143. Okay. So first, let us talk about the background of this issue. Have you heard of the Office of Governor? Have you heard of the Office of Governor? Who is a governor? क्या करता है गवर्नर? Under Article 200 of the Constitution, whenever State Legislative Assembly passes a bill and presents it to the governor of a state for his signing, the governor has three options. The governor can give assent to the bill. The governor can withhold the assent to that bill and send it for the reconsideration of the State Legislative Assembly. And third is that the governor can reserve the bill for President's reconsideration. ये लिख लो कहीं, write this down somewhere. Whatever I'm scribbling on the board na, keep writing. I will tell you what not to write, okay? So whenever governor is presented the bill which has been passed by the state legislative assembly, governor has three options. Sign the bill, which is called as give assent. Not sign the bill, but not signing the bill has to mean that governor has to send this back to the state legislative assembly. And third option that is there with the governor is to reserve the bill for president's reconsideration, which means president would sign that bill. Why do you need to sign the bill? First of all, any idea? Any idea? Because for any bill to become a law or to become an act, that needs the signature of governor in case of state legislative assembly, or in case of Parliament of India, it needs the signature of president. Then only it would become a law or it would become an act, right? So that is why this is a constitutional requirement. Now what was happening, this you don't have to scramble, that governor or governors of many states who are appointed by center, they were not giving assent to bills which were passed by legislatures or governments ruled by opposition party. Can you name the states? Tamil Nadu, Kerala, earlier it used to happen in West Bengal. What is common between these states? These states are ruled by parties who are not there in the central government, basically opposition parties. So that is why this issue was taken by these states into which court? सुप्रीम कोर्ट. तो ये मैटर पहुंच गया सुप्रीम कोर्ट के पास. They went to Supreme Court and complained that, see, governors, they are not giving their assent to the bills which we have passed through the state legislative assembly just because we are the state who are ruled by opposition party. So any idea what Supreme Court did? A two-judge bench of Supreme Court in April 2025 gave a judgment which created a lot of tension. Supreme Court, first of all, imposed timelines. It imposed timeline on governor that whenever you get a bill which has been passed by the state legislative assembly, you have 3 months to give assent or to not give assent. And if you have referred this bill for reconsideration of the state legislature and if they send this bill back to you, you have to give assent within 1 month. Second timeline they imposed was on President of India, saying that when the bill is reserved by the governor for your reconsideration, you have to decide to give assent or not to give assent within 3 months. Second, which was more problematic in this judgment, was that Supreme Court came up with a concept called as deemed assent. Now, who gives this assent to the bill? After that, it becomes a law. Who has the power to give assent to the bill? बताओ किसकी अथॉरिटी होती है? इट्स ईदर प्रेसिडेंट्स और इट्स ईदर गवर्नर्स अथॉरिटी टू गिव एसेंट टू अ बिल. But Supreme Court used extraordinary power under Article 142 to provide deem assent to the bills, as many as 10 bills of State Legislative Assembly of Tamil Nadu. So instead of governor giving this assent, it was not governor who gave this assent, but it was Supreme Court who gave this assent under the concept of deemed assent. Don't you think it's problematic? Why is it problematic? Why am I calling it problematic? It violates separation of power, and this is an instance of judicial overreach. What is judicial overreach? Judicial overreach is when judiciary does something which is originally meant for legislature or the executive. Yes. And in this problematic was constitution does not impose a timeline. Constitution uses the word as soon as possible. So when constitution is saying as soon as possible, who is the judiciary to impose timelines on another organs of the state? This was the second problematic condition. So you know what happened? President of India used her constitutional power given to her under Article 143. What is Article 143? That president has the power to seek Supreme Court's legal opinion on any matter of law or fact which has arisen or are likely to arise. What does Article 143 say? It says that President can seek the court's legal opinion on a matter or a question of law or fact which has arisen or is likely to arise. And this is a matter of public importance. And Supreme Court may refer to the question or consider this question and give their legal opinion. Or Supreme Court may consider this question and may give their legal opinion. Now my question to you is it compulsory for Supreme Court to give their legal opinion? बताओ, is it compulsory for Supreme Court to give this legal opinion? No, not compulsory, because the word written in Constitution is may. So before this reference, there has been 15 times question was asked to the Supreme Court, and Supreme Court has not given answers in 2 different times. किस समय दिया था? Not important. But this is on the discretion of Supreme Court whether they have to give this opinion or not. Second is, if the Supreme Court indeed gives the opinion, then is it binding on the precedent? Batao, second question. It is not binding because Supreme Court has 2 jurisdiction. First is adjudicatory jurisdiction. In using its authority under adjudicatory decision or adjudicatory jurisdiction, this becomes binding on the government or on any parties. But the second jurisdiction that Supreme Court has is its advisory jurisdiction, and in this case it is not binding on the government. Understood? Now my next question is, who is asking the question? Is it President's discretion to ask this question? No, it is not President's discretion. Here, President is acting on aid and advice of Centre's Council of Ministers. Yes. Now my next question is, now how many judges are there in Supreme Court? How many judges are there in Supreme Court? How many judges are there in Supreme Court of India? Supreme Court of India has Chief Justice of India and 33 other judges. So when President is asking for Supreme Court's legal opinion, so who will give the legal opinion? Only the CJI or the entire 34 judges or some number of judges? किसका लीगल ओपिनियन आएगा यहां पे? It is a constitutional bench of 5 judges who gives their opinion, and this is what is called as the opinion of Supreme Court here. Five judges bench. Any bench which has more than equal to or more than 5 bench is called as constitutional bench. Understood this term? So whenever there is a reference called as constitutional bench, you refer to it as 5 or more than 5 judges. Okay? अभी तक समझ आ गया? Any doubt you have right now, till right now? Yes, most of the time CJI is there in the 5 benches, but it is not mandatory for CJI to be there. Most time he will be there because he's the one who constitutes the benches, and why wouldn't he miss an opportunity to be there in a 5 judge bench? But it is not legally mandatory for CJI to be there. Understood? वो रहते हैं? Yes. उनको रहना ही है? No. He is there? Yes. He has to be there? Not necessary. Now let us take what kind of questions were asked by the president and what were the responses of Supreme Court for those questions. This is also very important. Any idea of the kind of questions that was asked by President of India? Any doubts up till now? You can ask, otherwise I'll move forward. कोई शर्माना नहीं है डाउट्स पूछने में. Because this is a very important topic. It is very likely that this might come in the exam in both prelims and mains. First question that was asked by the President of India is that what options does governor have when they are presented a bill under Article 200? What did I tell you? What 3 options does governor have? Give assent. Second is withhold assent. Third is reserve this bill for reconsideration of President. So in this question, the Supreme Court stated that these 3 options governor has. But if governor does not give assent to the bill, which is called as withholding of the assent, it does not mean that the governor just simply withholds the assent. If governor withholds this assent, this has to be sent back for reconsideration of State Legislative Assembly. Understood? तो खाली साइन नहीं करके बैठ नहीं जाना है. You'll have to send it back to the assembly. This was the first question. Second question was, is governor bound by aid and advice of Council of Ministers? This was the second question asked by Madam President. Have you heard of Article 163? Anyone? What is Article 163? Article 163, it states that the governor must act on the aid and advice of Council of Ministers. But the second part of this very provision of the Constitution, it states that governor has to act on the aid and advice of Council of Minister except when Constitution requires them to exercise their discretion. So it is Constitution giving them the discretion. So here Supreme Court stated that when giving assent to the bills, the governor is not bound by the aid and advice of Council of Ministers, which means it is governor's discretionary power. Because had it not been the discretionary power, then when a bill passed in the state legislative assembly, automatically that would be the government's bill. So how will the governor, if he has to follow the aid and advice of Council of Ministers, how will the governor be able to not give assent to the bill? So this was the reason why this is a discretionary power of the governor, not the power which he has to exercise with aid and advice of the Council of Ministers. Understood? Any doubts up till now? The third question was the decision taken by governor under his power of constitutional discretion when exercising assent over bill under Article 200, is it a subject of judicial review? What do you think the answer of Supreme Court was? Supreme Court stated that the merits of the decision considered by governor or the substantive decision made by governor after consideration of merit, it is not subjected to judicial review. But if governor prolonged, unexplained, or indefinitely delayed his decision, then it is subjected to judicial review. So in this case, if governor indefinitely delays decision making, then they can be directed by courts. Understood? So the decision, if the governor takes, that is not subjected to judicial review. But if governor does not take the decision, then the courts can poke them to take the decision. Now the president said that Article 361 provides governor or governor's decision immunity to judicial review. Have you heard of this provision? Article 361. That they are not answerable. They are not answerable to court for exercise of their official capacity. So Supreme Court, the president asked the question to Supreme Court that when Article 361 gives the immunity to governor, makes them not answerable to the court for any decision taken under their official capacity, so who are you to review their decisions? So Supreme Court in this question stated that this article gives governor the personal immunity. It gives governor the personal immunity. So it protects the individual who is there in the office of governor. It does not protect the office of governor. It does not protect the office of governor. So this use of personal immunity cannot be used as a shield for inaction. Understood? Any doubts? So the governor won't have to explain to the court why he did not give the assent. But if governor or the office of governor delays the decision making, then the Supreme Court or any court for that matter, High Court also, they can direct the office of governor to make a decision. What decision they can't say, but to take the decision it can be directed. Understood? Any doubts up till now? This is a bit complex. So if you have any doubt, you can frankly ask me right now. करिश्मा के अलावा भी कोई जवाब दे दो. I know Karishma is a lawyer by profession or is studying law by profession. So she would have somewhat better understanding than people who do not come from a law background. So others can also answer if it is clear. Now I told you, Supreme Court imposed timelines on both governor and president. So the next question was, can you indeed impose timeline on governor? Supreme Court stated, no, we can't. and therefore they overruled the judgment that came in April 2025. Supreme Court, in their legal opinion, stated that Article 200 uses the word as soon as possible, but it does not give any strict timeline. So we can't impose timelines on governor. Then came Article 201. What is Article 201? This deals with bills reserved by governor for reconsideration by president. So the decision of president, is it subjected to judicial review or not? This was the sixth question. What do you think Supreme Court said in this regard? It stated that similar to governor, this decision is not subjected to judicial review. Seventh question was, can timelines be imposed on president? Supreme Court stated, no, we can't impose timelines on president. Eighth question was that, can courts adjudicate on contents of the bill? The court said that bills are proposed legislation and acts are enacted legislation. So courts cannot adjudicate on the contents of the bill. Only when it has become an act, then only it can be judicially reviewed by the courts. Why? Because enacting a bill is a domain of legislature, not the courts. The next question was, can a bill become an act without governor's assent? Or without president's assent? The court said, no, it can't. A bill would only become an act with governor's or president's assent. Next question was pertaining to Article 145(3). You know why this question came? What is Article 145(3) first of all? Article 145(3) says that a matter of constitutional importance has to be heard by a constitutional bench. Has to be heard by a constitutional bench. So the question was, when any issue is brought to Supreme Court, should the Supreme Court consider whether it is an matter of constitutional importance or not, and then only refer it to a desired bench? So the court declined to answer. They did not give an answer to this question. So he said that the court, or this case, was referring to the powers of governor and president. So according to court, this matter was irrelevant to the larger nature of the questions that was asked by the president. Understood? So court declined to answer. The next question was nature of power under Article 142. Just Google Article 142 and tell me what does the word article, or what is the words written in the Constitution under Article 142. Can anyone tell me? It refers power to do complete justice, and it is an inherent power. So the question was whether power under Article 142 can be exercised with respect to any procedural issues, or it is a wider power which can be exercised even if it is inconsistent with laws or constitutional provision. So it means that can you follow the law of the land and give a direction using the existing law, or can you override the law and issue new directions altogether? This was the question asked by the president. You know what the answer of court was? Court stated that this is a question too broad to answer. And said that we have made it clear in our judgment that Article 142 cannot be used to override the procedural requirement of assent. What is the procedural requirement of assent? Karishma, you won't answer it. What is the procedural requirement of assent? Batao, anyone? Who gives the assent? It is the governor or the president who gives the assent. So courts cannot give this assent using the power under Article 142. Understood? So they cleared is that we can't use the power given to us under Article 142 to give a certain direction which is not there in the law or in the constitution or which is inconsistent with the law or constitution. We can give directions pertaining to something which you have already mentioned somewhere. Understood? The last question was Article 131 gives Supreme Court original jurisdiction to hear disputes between center and states. So can Supreme Court hear disputes under any other provision? The Supreme Court declined to answer. Said that this is irrelevant to the larger question that we were dealing with right now. Understood? Article 32 is right to constitutional remedies. फंडामेंटल राइट्स किसको दिया जाता है? करिश्मा, फंडामेंटल राइट्स आर गिवन टू individuals. Against whom? Against the state. State here means union, state government, or any PSU even for that matter. So when fundamental right is violated, it is individual versus the state, not union versus the state. So Article 142 is not an option where states can file a case against central government. Rights, for that matter, are rights given to individuals. Rights are not given to governments. Government के पास right नहीं है. Right individuals, मेरे और आपके पास है. So when it will be violated, we can take the state government or union government to court. They can't each other. उनके पास Article 131 है. Anything in this discussion that you did not understand? I realize this is a very important topic, and since you must be reading so many articles, I thought I would take my own sweet time and explain it to you perfectly. This is a very important topic. I hope you have written all the notes. Well, Article 142 states that Supreme Court has extraordinary power to do complete justice on any matter. This is what Article 142 states. So in doing this complete justice, the question here was, is Supreme Court bound by any procedural or constitution law that exists? Or using this power, can Supreme Court go against any law or constitutional provision? This was the question, very valid question. So Supreme Court stated that this is too broad for us to answer right now, but I will make it very certain that we can't use this power to violate procedural requirement which is there for assent. So it stated that we can't give the assent because the procedural requirement for assent under Article 200 and 201 is that only governor and president can give it. So we can't. So they gave a very limited answer. Understood, Pulla Shri Sharan? Supreme Court can give its own judgment by making the law inconsistent. But keeping the law, it can't direct something parallel. Whose authority is to make laws? It is the authority of legislature. What Supreme Court can do? It can invalidate a law if it is wrong. But Supreme Court can't make a parallel law, na? If suppose law says that killing someone is a crime punishable by death, okay? Supreme Court can't say that killing someone is punishable by only 5 years of prison, right? So you can't have two separate laws in the country. So Supreme Court can't use Article 142 to give itself a lawmaking power. It can suggest what is wrong, but it can't make a new law. Understood this difference? Its work is to interpret, not legislate. Very good, Karishma. Law दिख रहा है यहाँ पर. It's showing. अभी फिर से पूछ रहा हूं. Any doubts? What is NCA, Varsha? Supreme Court is not just a national court of appeal. Supreme Court also is a constitutional court. Supreme Court has two different authorities. It is a court of appeal and it is also a constitutional court. It can decide on constitutional matters also. It's okay. If you have any doubt in science and medicine, you can always ask me. I can understand everything just to make it work. So, go everyone, have a good weekend. We'll meet on Monday where we'll cover the rest of articles. I realized this is a very important discussion, so I took my time just to discuss this. ऊपर से भी मैं करा सकता था, but क्या point होता? Many of you, I'm 100% sure, not have attended your polity classes. How many of you haven't attended polity classes? उसमें भी इतना डिटेल में नहीं पढ़ाएंगे जो ये पढ़ा कर आया हूं मैं. तो समझ आ गया ना क्या है? व्हाट इज 142, व्हाट इज 143, व्हाट इज 200, व्हाट इज 201. Okay. So goodbye everyone. We'll meet each other on. वर्षा, क्लास वापस देखने की जरूरत नहीं है. इफ यू हैव मिस्ड आउट ऑन अगस्त का करंट अफेयर्स ना, just read the August wala magazine. I will come up with a question, okay? I will show you the question also. I guess article 142, they have asked a question. Just go through UPSC PYQs. On article 142, they've asked a question. So similar question can be asked for 143 also. Vishnu, there is a question on article 142 or even on article 21. Similar kind of question can be asked. That is in prelims. In mains, they can ask you to address various different points what Supreme Court said. So in this, our discussion would be very handy. Okay, everyone, have a good weekend. Yes, Civil IQ has been provided to us. You can use that. Just go through it. If you have any doubt, you can ask me. You have my mail ID, Varsha? My mail ID, if any one of you have a doubt, is ankit.singh1@studiiq.com. Okay? So you can ask any of your doubts on this particular email. You can also use the Telegram group. But agar Telegram group mein, if you have problems in making your doubts visible to everyone, this is also you can use. So have a good weekend, everyone. We'll meet each other on Monday.